All right, guys, welcome back. Attorney Steve Vondran here. Today we're looking at artificial intelligence, OpenAI, and what this cool product might be able to do to help you grow your law firm. All right, so this is OpenAI. I really like this one. It's not perfect. It's not a 100% foolproof solution. I have found errors. I have found cases that don't make sense. But I have found it to be pretty cool for a lot of other things. Get a letter started or get a pleading started or just for some general information that may be on your mind. So I just typed in here. I'm going to give you a couple examples in this video of some ways you might be able to use it. And there's so many ideas that you can come up with. It's crazy. So I'll just give you a few here. Describe what the hottest legal practice areas are for the year 2024 for lawyers who want to make a lot of money. So this is more of a, hey, can you forecast what's going to be really hot? Let's take a look. Technology law, yes, that's one area I'm in. Technology law continues to shape our lives. It's going to be high demand, EDD, intellectual property, privacy, data protection, cybersecurity, artificial intelligence, and blockchain. Right now we're seeing a ton of scams in the blockchain, so be very careful with that. Litigation, that's another hot area for Vondran Legal, attorneysteve.com. We do a lot of litigation, so that's good. It looks like I'll be in demand here for at least the next year or so. This includes civil and commercial litigation, class action lawsuits, and other matters such as whistleblower, antitrust, securities litigation. Immigration law, the world's moving, it's turning, moving fast. Immigration law is a very hot area. Another one I like, it's not on this list, but tax law. If you're really good at tax law, and I also think like medical, biomed, I think those are my own opinions. But let's go down. Number 4, intellectual property law. That's what I do. Copyright law, software, trademarks, trade secrets, infringement, licensing, all that. Number 4. It looks like I'm in a pretty good practice area the closer I look at this. So, and finally, corporate law. That would be like your mergers and acquisitions, your contracts, and all kinds of things. And one other one I'll leave on here, which is always a stable in the legal marketplace, is I would say family law is always if you want to be a lawyer and always have business, family law is one good way to do that. And and employment law. Half the lawsuits in the United States are employment related, or somewhere there's about. Okay, so if you think about all of these things, this is what's hot, at least according to OpenAI. So it's pretty cool. Pretty cool just to gain general information. This could help you start or write a blog, put a description in one of your videos or whatnot. So it's pretty cool. So let's just start with real quick here. One thing you can do is have it write a contract for you, okay? Now, I'm not saying these things are going to be ironclad, you know, the perfect contract with every clause to meet your needs. But if you're looking for something basic, here I have write a contract between a buyer of a painting selling it for $1 million to a buyer, okay? So I like to make sure I get some full length up here. Submit, and let's see what we come up with here. This contract is made between the seller and the buyer. Whereas the seller is selling the painting, you could describe the painting in more detail there. Where a buyer has expressed an interest in purchasing the painting, now therefore in consideration. That's the glue that holds the contract together. Whoops, I'm running out of power there. And some real basic terms. Here's the sale of the painting. Seller agrees to sell, buyer agrees to purchase, $1 million. Purchase price, you can say when it's going to purchase. Representations and warranties. Seller represents that they have title to the painting, this, that, and the other. Boom. So you can see that's real quick, a contract. Now, this doesn't have every term that I would put into a contract by any means, but for very simple things and to get an idea, this is one really cool use. All right, let's give this one a try. Checklist. I like this. I like to use these for checklists. This is pretty cool. Watch. Generate a list of the top 10 tips for a documentary filmmaker when trying to use unlicensed videos and photographs under the fair use doctrine of the United States copyright laws. So let's get a quick list of tips that will help us with fair use and prevent us from being sued for infringement. Go, OpenAI, go. 1, make sure the material is for educational, nonprofit, or commentary. 2, make sure the material is used for transformative. If you're transforming something, making something new, that's very key. 3, keep the amount of material used to the minimum required for the purpose. I call this the minimum necessary. 4, consider the potential market of the value of the material if it was licensed. 5, document the purpose of the use and its need for the documentary. 6, make sure the material is not used as a substitute to purchase the licensed material. 7, make sure the material is not used to create a derivative work. Why? The copyright owner has the rights to derivative works. So you need to transform it so it's not a derivative work. Make a parody out of it, for example. 8, do not use more material than necessary to achieve the purpose. So you can see it kind of repeated itself. With number 3, that's kind of repetitive. So that does happen. This is not a perfect system, as I mentioned. Number 9, consider the source of the material and the impact use on the copyright holder. You can always give them attribution or a link to their website, things like that. And 10, seek permission from the copyright holder. Well, that's not really relying on the fair use doctrine, but if you seek permission, that could help you as well, because at least you tried, right? That may help you with the fair use argument. Not always. So anyway, OpenAI, very cool for making quick checklists. Very cool. All right, another good use of OpenAI, artificial intelligence for lawyers, is just getting quick definitions. Here I put in, describe in detail the difference between a default being entered and a default judgment in federal court in the United States. Let's see what it gives us here. A default being entered in is a court action initiated by a plaintiff when a defendant fails to respond to the lawsuit within the allotted time. Federal court, you have 21 days. Usually state courts, many are 30 days, but not all. Check your local rules. The court will enter a default against the defendant, and it will be noted in the court's records. This does not mean that the plaintiff has won the case. It just means that defendant has failed to respond, and the plaintiff may continue to pursue the lawsuit. A default judgment, on the other hand, is a judgment issued by a court in favor of the plaintiff when the defendant fails to respond to a lawsuit. In this case, the court has accepted the facts as presented by the plaintiff and has made a decision in favor of the plaintiff without a trial. The defendant does not have the opportunity to present evidence or make arguments in their defense. Why? Because they've basically admitted to all the merits. What we call the well-pled merits of the case have been conceded to when you don't respond, and the judgment is considered final. So there you go. It's pretty cool. It gives you quick, if you're struggling between two legal concepts, it will help you understand these things a little bit easier. All right, here's the last one I'm going to try. This one may be helpful if you're writing blogs or descriptions for your videos and things like that. Generate a 1,000-word legal blog discussing the elements needed to prove trademark infringement in the Ninth Circuit. So I'm specific. Include case citations and a summary of the case. Let's see what that will give us. Ready, go. Trademark infringement is a type of intellectual property violation that occurs when a person or entity uses trademark, service mark, or trade name that is identical or similar to a trademark owned by another party. In the Ninth Circuit, the element needed to prove trademark infringement include a valid trademark, likelihood of confusion, and actual use of the trademark. The following blog will discuss each of these elements in more detail and provide case citations to illustrate how they have been applied. You need a valid trademark. You need likelihood of confusion, actual use of a trademark. And again, I have found these to be good, but not 100% accurate. And here, matter of fact, I asked for case citations and I didn't get any. Well, they did have one in here. Mattel, they had a case, so there was a case, but I have found some of these citations to be off. Here's another one. I guess that's the same case. So they gave me just one case, a little bit repetitive. I found these cases to be a little bit off. You do need to check the citations, but it gives you, again, a good little framework to move forward on a project, on a brief, or on a demand letter, whatever you may be working on. So it's pretty cool. I like a lot of the things I'm seeing. I think it's got a ways to go to really become even more valuable, but for now I think it's a pretty good start, and OpenAI, pretty cool tool for the budding lawyer. Okay? Have a great day, everybody. I hope you enjoyed this general legal information only and not legal advice. Have a great day. We'll be back with more great videos. Don't forget to subscribe. If you need more help, civil litigation, intellectual property, entertainment law, find us on the web at attorneysteve.com. That's attorneysteve.com. Lisa, Mr. Q, the first name in legal services. Okay, I got to run, everybody. Bye now.